Welcome to the BBB National Programs podcast, Better Series, where we will explore top-of-mind topics and self-regulation with business and industry leaders. Together we seek to understand the leading trends and innovations that continue to push the envelope in today's marketplace.
Thank you for joining us today on the Better Series podcast. I'm James Lee. Nearly 2 years ago, the California legislature passed the most comprehensive privacy and cybersecurity law in the United States, the California Consumer Privacy Act, or CCPA. The law gives consumers a wide range of rights and creates a series of obligations for businesses, from giving consumers access to the information about them to acting on customer requests that businesses do not sell a consumer's data for marketing purposes. And then there are the potential fines, the largest in the U.S., as well as the ability of consumers to sue companies directly for damages for violations of certain provisions. The CCPA went into effect on January 1st of this year, but the enforcement date of the Act was July 1st. And while the plain language of the Act gives us a general idea of what the law requires, it is the regulations proposed by the California Attorney General that gives us a somewhat clearer roadmap to compliance. And just when we thought we knew what the CCPA requires, there is now the prospect of voters strengthening the Act in November thanks to a new ballot initiative. You combine that with a series of CCPA lawsuits that are already filed, and you have all of the ingredients needed to shape the nature of privacy in the U.S. for years to come. Julian Flamant is a Privacy and Cybersecurity Associate at Hogan Lovells. Heather Federman is Vice President of Privacy and Policy at BigID. And Cobun Zweifel-Keegan is a privacy lawyer with the BBB National Programs working to build new accountability initiatives for the future of privacy. They're joining us today to talk about all things CCPA, what it means for the U.S. businesses, and what's on the horizon. So everyone, thanks for joining us today.
Thanks so much for having us.
So Cobun, you talk first, so I'm going to ask you first. Let's get started with a quick refresher to bring everybody up to speed. What is actually included in the CCPA? What does it do for consumers, and what does it do for businesses?
Thank you, James, for that question. The CCPA is really the first law in the United States that starts to provide for some of the GDPR style requirements that we are beginning to see as best practices for privacy. So that includes things like consumer rights, like the right to access that you just mentioned, although the CCPA really is unique in its understanding of some of those rights, and it really focuses operationally on this do not sell requirement, allowing consumers to opt out of the sale of their personal information, which is a little bit of a different way of thinking about it than other laws that we've seen. In terms of operations, it's requiring lots of updates to data processing agreements between different types of companies, and a lot of the usual types of updates in internal privacy practices to make sure that companies understand where their data comes from, where it's going to, who they share it with, whether they do sell it, which is some question. There's some contention there of what that really means, and then how to implement some of the consumer rights that CCPA provides for. That really has shown in practice to have there's been quite a bit of uncertainty in the marketplace as companies have tried to implement this regulation, the law and the draft regulations sort of in real time with a fairly short lead up time compared to some prior laws that we've seen. And that has caused, I think, a considerable amount of friction in between businesses in particular, as people have really thought of the law in different ways. And that is something that I think is beginning to start to play itself out as we sit in this particular moment where CCPA is just about to be implemented, about to go into force, and we'll start to begin seeing enforcement actions even as it continues even as the story continues to change. And so I think that was part of the idea behind this episode today, is to really focus on this moment, as which is a pretty unique environment, where we're just at the beginning of enforcement after a long period of time of uncertainty and lead up and implementation, and moving on to sort of the next stage.
Julian, let's build on that. In your practice, which focuses a lot in these areas, this law was passed by the legislature in 2018. There were some amendments in 2019. So people have had a time to look at it. The regulations have had less time to look at. So how has this view of the law changed in this continuum? Do we still think of it the same way we did in 2018 when it first passed, as this sort of rapid release of a bill that came together in 10 to 14 days? Do we still view it the same way now, today, looking back and looking at what the regulations are, or is it evolving and evolving rapidly? Our understanding.
Well, thanks, James. I do think that you could kind of characterize it as evolving. So obviously, the Attorney General received significant authority from the text of the CCPA to further outline certain areas. But I think the important thing there is that while the Attorney General, for example, was asked to outline verification procedures for consumers who submit rights requests, the Attorney General also kind of significantly outlined, or kind of further described some of the compliance obligations that companies had. And by the way, I just want to go back, because Cobun kind of characterized this as something that's changing, and I think that's absolutely true. We can't forget that, while the CCPA statute was passed in June 2018, the initial regulations from the Attorney General didn't come out until October 2019, just a couple of months or a few months before the CCPA would enter into force, which was January 1st, 2020. And then there was a first set of modifications that came out in February, and a second set of modifications that came out in March. And with each, there were some changes that businesses kind of had to take account of in building out their compliance procedures. And kind of a good way to think about it is that the initial draft regulations were pretty strict, or not so much strict, but took a very conservative approach to some of the obligations. And then in February, the Attorney General rolled some of those back. I think an important provision that came out with the February release was how businesses could think about personal information, and that personal information that the business did not maintain in a way that would allow it to identify an individual or household would not be personal information within the meaning of the act. But then that was something that was rolled back in the March release, leaving some uncertainty, or some of that original uncertainty, about the true scope of personal information. The Attorney General also made some important clarifications. For example, the definition of household. The CCPA contains a pretty broad definition of the types of information it covers, which are personal information. And that's the information related not only to individual consumers, but as well to households, which is undefined in the statute, and initially was not defined clearly in the regulations. They were just defined as, individuals in a single dwelling. But as the drafts evolved, that definition as well evolved with some clarity now, kind of limiting the scope of household. And so this very much is something that has been evolving since the CCPA was passed in June 2018, but certainly since the initial regulations came out in October 2019. And assuming that those now are final, there shouldn't be any more changes, but businesses, in a way still don't have clarity on what exactly is required of them, because what's happened is that the Attorney General submitted final regulations for approval by the California Office of Administrative Law, but the OAL, that office, has not yet approved and implemented the regulations. And so we're in a situation now where, as of July 1st, which at the time of recording was yesterday, the Attorney General could start enforcing the CCPA, but all of the clarifications that came through and the additional requirements, or I guess the clarified requirements that came through in the regs, technically are not yet implemented. And so this has, kind of furthered the uncertainty that businesses are facing related to the exact obligations under the CCPA.
Well, uncertainty is the word of the boarding, it sounds like then.
Yeah.
Heather, businesses hate uncertainty. They need that level of stability to be able to plan and do the things that successful businesses do on a daily basis. What have they been doing to get ready to comply with clearly something that they're not really sure what they need to do to comply with?
And I mean, you're right, James, and thank you for having me. It's been a bit of a cluster because there hasn't really been any certainty as to what can you do. And in a business context, you typically want to know how you're going to execute, how you're going to operationalize something. And that isn't always clear right now. So one thing that I've heard from other businesses and stakeholders and myself as well is just essentially applying the 80-20 rule of just understanding that you probably won't be able to achieve 100% compliance with this law because there's a lot going on here. And as we've been saying, this law it seems to be constantly changing, and the only constant in life is change. But if we can get the main core competencies and features of this law built into our privacy program, embedded within our business operations, then we could at least be in a much better place and not in the place of maybe tearing our hair out trying to figure out what's going on here. And so when I think of what is within that 80%, I think of in terms of, well, what's the data that we're actually dealing with? So step 0 for any organization is to really be able to say, okay, these are all the data assets I have, and this might be what is covered under this ever-changing definition of personal information. Because from there, we can classify our data, we can tag our data, we can figure out what we need to do with our data, and that helps us fulfill the other piece of this puzzle, which is part of this law about the consumer data rights obligations. So if someone wants to know the data that a company would have about them, well, I have to know where that data is within my systems and figure out the right way to be able to provide a report on what that data is and be able to repeat this process again and again and again. So it's figuring out that 80% of, okay, here is my data, here's the way I'm going to operationalize this program for CCPA and be able to do this in a way that is scalable and hopefully automated. It might be dependent upon the type of business you're dealing with, because some businesses might not be getting a whole lot of consumer requests right now. Perhaps they're not a consumer-facing company, or they're not in a hot seat, so there hasn't been any PR about them lately. But it's the sort of thing that even if you aren't necessarily a consumer-facing company that's constantly in the news, you still need to be considering right now. Because if there were a data breach, well, there are provisions in this regulation that you could have a class action or a private right of action. So I really think that's kind of what businesses have to consider, is that we can't ignore this, but we can't drive ourselves crazy. And I look to someone like Julian to help me understand the finer points of this law as they're constantly evolving. But in the meantime, I have to consider what's the most practical approach to get through here.
Probably a good time to point out that this law is extraterritorial. You don't have to be in California for it to apply to you. So, Cobun, has there been any best practice emerge yet from inside the state or businesses outside the state, or for someone who looks to help organizations comply and find the best way to do that? What are you seeing?
Yeah, and to clarify, I think for businesses, they don't have to be headquartered in California for it to apply to them for sure, because they're going to be processing the data of consumers in California as defined under the rules. Um, the That's a very good question when you're thinking about how companies are actually both implementing the actual requirements of this law and also looking to the future, because I think we all know that this isn't going to be the last piece of privacy legislation or regulation that we see um, setting the standards, the minimum standards for privacy best practices moving forward. So I think a lot of companies really are seizing the actually looking at the uncertainty as an opportunity to set themselves apart in terms of privacy compliance. So you see, for example, like Microsoft saying, we're going to apply CCPA rights to everywhere across the board. And I think there's some differentiation there. I would like to hear from the others actually whether they see that as a standard practice. I think some companies, often it's easier, depending on how your data is structured, to just apply new rights to all of your users, rather than try to create two sets of rules for different types of users. But it really depends on the business. So it's interesting to see how that's developed. That's been one thing that I've asked a number of companies about, and I get many different answers to that question.
Yeah, Cobin, I can jump in there. The I agree that the CCPA is something that impacts the practices of businesses outside of California, because as you mentioned, it can be difficult to implement various compliance practices depending solely on who the consumer is at the time. And this is something that we saw with the European Union's General Data Protection Regulation, was that some um, controllers under that law, or some businesses, decided to implement the rights arising out of the GDPR globally. And so that certainly is something that I think we're seeing under CCPA, where a business would, for example, commit to honoring uh, consumer rights requests for any U.S. consumer. But I don't think it's the norm, and I think, and I'm not sure it will emerge as such, because it's one thing to commit to providing rights to individuals or to users outside of California, but it's another to really go through the kind of back end processes that a business needs to do to be able to provide those rights. And so it requires substantial data mapping, for example, and also just really understanding the way your business is structured, and also what type of sharing you're doing with third parties, or more to the point, service providers under the law. And so I'm not sure that applying CCPA more broadly would really become the norm, or there might be a situation where there would be a more limited application. So, for example, a business would say, under the CCPA, California consumers have the right to access information about our collection and use of their information. That might be something that that the business is able to offer to consumers outside of California, whereas, for example, the data deletion right arising under the CCPA would be more difficult to implement more broadly, and frankly, it could, substantially disrupt business practices if it were applied more broadly. So I think while we are seeing some companies applying these rights or CCPA compliance measures more broadly, we're still seeing, notices that are specifically tailored to California consumers that include all of the disclosures that are required under the CCPA, and the same would go for providing consumer rights.
Yeah, I'm just gonna jump in there. I agree with Julian's perspective on this. That I think for the time being, we're going to see a California only approach as the majority for businesses. And also, businesses can also, at the very beginning of the process, basically gate out anyone who's not from California, because part of what this law requires is that you have to verify a consumer's identity in order to fulfill their request in exercising one of these rights. And in that process, you can basically ask someone, well, where are you from? So you kind of actually have to know the consumer before you can give them more information about what you have about them. But in that process, you can determine, okay, is this a California resident? If not, I can send them a friendly message saying we're not honoring requests from outside of California at this time. So you could keep it as simple as that. It might not always look great from a, business PR perspective, but that is a stance that many businesses have taken.
So we're in the middle of a pandemic, so there's not a lot of normal. There's certainly, we're not playing baseball right now when we should be, but here comes a curveball. We're now know that in California in November, there is going to be on the ballot the CPRA, the California Consumer Privacy Rights Act. So it's going to, if it passes, throw a whole new set of regulations and a whole new set of obligations onto business and rights given to consumers. What do we do about that?
Yeah, and before we even get into that, James, into like the details of that, I think that raises a really good point to what Heather and Julian were just talking about, which is that it feels to me that doing the California only approach sort of kicks the can down the road many times, because we know that most of these like access rights and deletion rights are going to be included and are included in basically every draft privacy legislation that we're seeing right now. And so, especially when you're already going through the motions of implementing a verification system and trying to figure out specifically how you're going to honor deletion requests for Californians, it just to some extent strikes me as funny that you would make that extra move of I don't know, of only applying that to certain people. Although I guess, I mean, at the end of the day, there's work required for each deletion request if it is a deletion request. So, and you can try to limit that to some extent. But for me, it seems that the PR benefit, the kind of thinking of it as a customer service aspect, so a way of building trust with consumers, actually outweighs that. So it's just interesting to hear how businesses have been approaching that at this time.
So how will that change when we get additional requirements, or will it?
Right, exactly. And so, yeah, and we can certainly move into the CPRA issue then as well.
I think I just wanted to pick up on your point, Cobun, which is that, you characterize not providing CCPA rights more broadly than to California consumers as kicking the can down the road. It's certainly true that new privacy laws, or really, I guess what we refer to as baseline privacy legislation, which is legislation that would regulate data, across various industries, are emerging in various places and are being considered, in a number of states. What's unclear is how similar to the CCPA those will be. So certainly, CCPA spinoff, which is kind of a term people like to use, is a thing, and various states have considered laws that really look a lot like the CCPA. The thing is, and you characterize the CCPA kind of at the opening of this podcast, it's really a law that's focused on sales. So that's disclosures of personal information to third parties for monetary or other valuable consideration. And so it's not clear to me whether this kind of sales focused legislation is really the way privacy laws are going to develop in other places. And James also mentioned the COVID aspect. I mean, I think it's important to note that once the CCPA came out, commentators or people in this community thought that states would kind of race to implement and would be able to approve and enact CCPA type laws. So that, first of all, that didn't happen, certainly not as quickly as some expected. Now, in addition, in this current legislative session, in the various legislators across the states, there were, again, as with last year, bills, probably in 10 plus privacy bills in 10 plus states, and those in most cases didn't gain too much traction. And then you had this COVID complication where a lot of the legislators had to close. And then not only did they have to close, but they were closed or on, kind of a public safety related hiatus until after their legislative session ended. And so because of that, I think it's unlikely that at least this year we're going to see um, we're going to see any meaningful privacy legislation emerge. I can't, talk about next year. I don't know what would come back. I think another important piece to talk about with this is the Washington Privacy Act, which, you know, got pretty close to passing twice. Now, it didn't include the sales piece, that the CCPA has, and really was kind of more of a law, kind of a GDPR spinoff, or a law similar to the General Data Protection Regulation in Europe. And even that, you know, did not pass, even though it went up twice. And actually, this year, in the second go round, it received approval from the House and approval from the Senate. And then, the two houses who had amended their own versions of the bill were unable to reach a resolution, citing really the key difference being on enforcement, whether to include a private right of action or not. And so, while I agree with what you said, that in some ways it's kicking the can down the road not to implement the CCPA more broadly, it's actually not clear the exact shape that privacy laws in other places or at the federal level will take. And so I think, a lot of businesses feel like, while they're required to do this now in California, and maybe some implementation of that more broadly, which is what I referenced with, for example, giving, maybe providing some of the rights more broadly where it's possible. Really doing a CCPA type implementation more broadly than California may be, unnecessarily burdensome.
Right, and I hear you there. That makes total sense, especially when I think it is the general consensus that CCPA, as we've been continuing to have these policy discussions, CCPA does feel more and more like a one-off. It does feel a little different than where consensus is, and it's kind of always felt that way. It was sort of uniquely crafted, and conceptual, and that focus on sale in particular.
And let me jump in here just so make sure we cover this, because we are coming close on time. There were provisions of GDPR which were very disruptive, particularly around notice, and it has effectively killed some of the practices that have been bedrock in digital advertising, for example, because you can't get notice in a meaningful way from consumers every time they click on a link, every time they go to a particular website. So it has been very disruptive in some areas. When we look at the CCPA and we look at what may be coming down the road with CPRA, assuming it does pass in November, is there anything in these two, the one existing law and the one proposed, that has the potential to be that kind of disruptor?
This is Julian. I can jump in on this one, which is that I think we're already seeing that disruption. So I think you're right, James, that, GDPR, maybe not precluded, but really, created an impasse for a lot of businesses, or at least forced them to think of new ways to deliver services and to maybe deliver different services. And a lot of that was based on the consent requirement. That's something that's kind of implicit in the CCPA because of the way it limits sharing with third parties. it takes a different approach, which is that it allows consumers to opt out of the types of sharing that, well, I guess it's still arguable, the exact scope of what's covered under the CCPA in terms of whether, cross-contextual advertising is, always going to be a sale. But certainly giving consumers the ability to opt out of that, and also requiring that businesses provide disclosures specifically related to those types of, that type of sharing with third parties, I think it can be a big disruptor. And I'll also mention that, in the lead up to implementation of the CCPA, we saw a number of bodies and large service providers release functionality associated with their tools that, that businesses can kind of adopt or enable, that would seriously affect the functioning of of the services they provide. So an example is the Google's restricted data processing functionality, and then more recently the Facebook limited data use functionality. Under both of those, when a business enables the tool, the service providers will treat the information as a service provider would need to under the CCPA to avoid a sale. And so what that does is it limits the effectiveness, for example, of ad campaigns and the analytics that the business would get back from the service provider. And so I do, we're already seeing that substantial impact.
Heather, with your customers, because you're helping them comply, are they even aware that CPRA is a potential? Is that even on their horizon yet? And if it is, what are they worried about with this version of the California privacy law?
Yeah, everyone's aware how much attention everyone's going to pay to it right now. That's a separate question. I mean, I think if we go back to that approach of being practical, it's looking at the implications of CPRA, of what are the big sweeping changes here, and saying, okay, well, how can we extend this? Because in some ways, it does bring it more on par with GDPR. So for a company that's already complying with GDPR, this may not be as big of a push. For a company where, let's say, they're more they have a US focus, then this might be a bigger push, especially in terms of some of the advertising implications. And that also comes up in the regulations for the AG, because the AG seems to talk about do not track, which, what does that even mean right now? Is there some sort of global enabled way to opt out? I'm not as quite sure. So I think there's a lot that's still really confusing and that's still changing. But I do also think it's somewhat exciting, and businesses want to do their best to comply. So I'm also seeing that as well. And just one other thought I wanted to put out there, as we were talking about earlier, the California versus other states, is that the way that CCPA and CPRA were created was very unique to the way that California lawmaking works. CCPA was initially a ballot initiative, which lobbyists and lawmakers were not happy about. And the group that proposed a ballot initiative, they took that away and allowed a compromise legislative bill to go in place, which is what we're seeing with CCPA today. The backers of CCPA, the Californians for Consumer Privacy, were not happy with what they've seen over the last 2 years since CCPA was signed into law. And that's how CPRA came about. And now it's on the ballot for November. Whether or not it's going to get passed, I don't know. But if it does get passed, then this is what we're stuck with in the States. But I also think that, we're waiting on that. We're waiting on the AG regulations. And then also it's going to take several years to really figure out what a lot of this means, because we'll start to see how this trickles out through the courts. We'll start to see, well, what does the AG really care about when it comes to enforcement? So there's still a lot of unknown variables. So So for the businesses that I've spoken with and for us, it's really trying to figure out what is the practical approach here? What is it that we can actually do to do our best?
Okay, we're going to give everybody one last word about the state of privacy and where we think it's going. So, and I know we'll get to revisit this later in the year because we are going to have an election. There is going to be a decision on CPRA, and so we're going to find out one way or the other whether the California law is going to change again. But Cobun, what's your thoughts on the state of play we have today?
Well, I think I've been impressed by Heather's comments about focusing on fundamentals and the fact that getting that 80% compliance as a goal is important, especially in terms of completing some of the overall compliance obligations like data mapping, which set you up for compliance with future rules. I think CPRA is going to be a big consideration, and it does include some pretty substantive changes from CCPA. There's opt-in requirements for sensitive information and a really broad definition of sensitive information, and this is going to start to dictate how businesses are really behaving. So I think the sooner people can kind of think ahead of what is going to set them up to do best by consumers, and to build trust in the marketplace, and to set themselves apart in some ways as a competitive advantage, I think the sooner they'll be prepared for things like CPRA and possible federal legislation coming down.
Julian, what's your thought?
Well, Cobun, I think those are some great points, and I agree as well that focusing on fundamentals is, an area to focus on. And I think one challenge, though, is that unlike the general data protection regulation, which kind of had this long legislative process and also had the directive before it, which was enforceable for 20 years, we don't really know how enforcement is going to develop in this area. And so the challenge with 80/20 is that, a company might be doing fundamentals, which are good practices anyway, but then, missing the mark in some way on CCPA, and that could create a lot of risk for the company. So again, I just want to reiterate, we don't know how the California Attorney General, what kind of enforcement posture the office is going to take, but certainly the statements that are coming out of that office have been, have signaled that there will be active enforcement, and that, maybe the attorney general, as of July 1st, has already taken some actions. The CCPA contains the 30-day cure period. And so kind of the first step would be to notify a business that they're in violation before actually bringing kind of an enforcement action and then making that public. But it may have started already. And so, I think businesses really need to drill down and make sure that they kind of check the boxes of CCPA, make sure that they have rights request processes in place, and as well that their disclosures comply with the CCPA. And then of course, if the CPRA gets passed in November, they kind of get to start all over again, to kind of update their internal processes and to make sure that they update their disclosures to meet the requirements of that law. And so this is kind of just a continuing thing. And so, fundamentals is a good place to start, but as well, there are some particularities in these laws, and especially as they develop with regulations, that really need to be drilled down on as well.
And Heather, you get the last word.
Yeah, Julian brings up a great point. While I'm all about the fundamentals, I wouldn't say ignore the particularities of the law either, of course. I think it's just really having to become okay with the sense of grayness, especially for those who work as a privacy practitioner. There's never anything that's going to be black and white about what it is that we do. And as much as we'd like the laws that we're trying to abide by to be black and white, that's definitely not the case here. And I think when it comes to enforcement, I think we will see the AG go after perhaps several egregious cases, but we have to keep in mind that, his office has a limited size, a limited budget. They have a political agenda. What I think will be interesting to see is if the CPRA does get passed in November, that requires a dedicated state agency for enforcing this law. And then if that becomes the case, then we really will need to think, well, how do these fundamentals plus particular aspects really come into full force? Because that could be a game changer.
Well, thanks, everyone. I'm very much looking forward to our next conversation when we find out what actually happened with the CPRA, because I can only imagine what will be the actions everyone has to take after that, particularly if you have the first in the nation state privacy enforcement agency. So that it will be fascinating conversation if it passes, and we'll still have plenty to talk about even if it doesn't. And thank you for listening to the BBB National Programs Better Series. Don't miss an episode by subscribing to the Better Series at our website, bbbprograms.org. Then click on the podcast tab. You'll find all our episodes there, where you can listen on your Apple Podcast app, iHeartRadio, or your favorite streaming platform.
You just enjoyed the Better Series podcast. Be sure to tune in next time for a brand new episode. To learn more about our other shows, visit betterbusiness.blueberry.com. That's betterbusiness.blueberry.com. Follow us on Twitter at BBB_NTL programs. Send your comments and ideas to podcast@bbbnp.org. The thoughts and opinions expressed on this podcast are the views and opinions of the guests, not those of the BBB National Programs or its affiliates. This podcast is for information and educational purposes only and is copyrighted with all rights reserved. This podcast is protected by Blueberry's Terms of Service.